Dear friends, this is video 2 with regard to the issue concerning the judgment of Honorable Madras High Court delivered by Justice Dr. Jayachandran. I am taking one judgment and then trying to explain various issues that emerge in the said judgment. From the beauty of the judgment, we have seen in para 29 and 30 how the interest of justice and the administration of justice was dealt with. Secondly, we can understand that the learned judge, looking at section 340 of CRPC and 195 1BC, 1ABC is there, and took the help of amicus curiae, and he presented the judgment in that paragraphs. We would like to deliberate upon that. What is the importance, how we tested step by step, whether there is any procedural violations, and what are the facts of the relevant facts of the case, and then concluded that the facts will establish the commitment of fraud, commitment which attracts section 191, 193 of the IPC. In spite of finding them guilty on that count, he refrained from issuing punishing the appellant. That is the, and for that reasons were given, cogent reasons were given. Why I have taken this particular judgment is, as a teacher, I believe that the entire subject of law, jurisprudence, like, facts, issue in facts, matter of fact, matter of law, and substantial question of law. These are the issues through which a scientific approach, when you are arguing a case before a high court or a Supreme Court, the highest courts of the state and the nation, you have to be thoroughly well prepared. Yesterday, recently, Justice Bella Trivedi on the Honorable Supreme Court took an exception to advocates coming unprepared, not able to answer the questions raised. So then lordships were telling that it is not right for every lawyer without much experience coming before the Supreme Court and argue the matter, because the time of the High Court or Supreme Court are highly precious. So many cases, and they cannot just like that decide the matter too. So I remember in one case, a challenge of the Honorable NCLAT under section 62. It is a statutory appeal. SLP means they get discretionary jurisdiction and they will dismiss it without giving reasons. But even in section 62 statutory appeal, also they will do that. But you have to establish. I will tell you a simple question, a simple example. This is a matter came before Honorable Justice Khanna and Sundaresh bench. And when the matter came before, my item was item 21. And when it came before, immediately Justice Sundaresh informed Justice Khanna that I am his friend. And therefore, he recused from the judgment, bench. So it was posted before Justice Abhay Voka bench. My opponents were IDBI Bank. IDBI Bank on this case, one case alone, has spent 300 lakhs on the legal fees. The topmost lawyers are appearing, starting from Tushar Mehta, Learned Senior Counsel, everybody, you name it, they are fighting in NCLAT, NCLT. So what happens is when top people appear and a normal person like me appearing party in person, They didn't give any opportunity of being heard. And the matter has come. And I felt that in tribunals, they don't listen to juniors and small people, only top people. Whatever lies they say, they will record the same thing and pass the order. At least in my case, that is my experience. Then this matter came. Honorable Justice Abhay Oka came. So as usual, the same senior counsel, remember, the same senior counsel who was paid 300 lakhs during the NCLT, NCLAT by a public sector bank, which normally pays 60, 70,000 for full case. In Chennai, if anybody argues one NCLT case, that lawyer will be paid only 60,000 maximum. And they will, everything you have to do. But for my case, but I am relentlessly trying this case. I am learning. And then whatever I learn, I must spread it to every student of law, younger advocates. This is my desire. So I was arguing before Honorable Justice Venugopal. When I explained to him this, what is the substantial question of law, then he smiled at me and then he dismissed that. He didn't hear because it was he gave a belief that already decided that the matter will be in favor of IDBI Bank. So whatever I said, they never took it. Then when it came to Justice Abhay Oka, that as usual, the IDBI Bank council started attacking. This man has done this, that. Then he said rule number 11, we have removed him. And section 16 of General Clauses Act, they have removed him. Then Honorable Justice Abhay Oka told, what is this 46 pages judgment of NCLAT, another 30 pages of NCLT. They have not discussed the main issue. And they are writing unconnected judgments, Lordship said. That is, he came, he said like this, while I coming, I read this papers and orders, and I find that the main issue is not deliberated. Then he asked me, what is the, he looked at me and they won't allow you to speak in NCLT, NCLT. But in Supreme Court, it's not possible like that. They are brilliant judges. They are just unbiased, extremely knowledgeable. Then he said, then I told Lordships, this is a complete code. This is a complete code. And in this code, the NCLT appointed me as liquidator. Under section 34(4) of the code. Now they only have to agitate what is that section 34(4) says and in what way the judgment is wrong in relation to the provisions. Is there any violation? Secondly, whenever there is a provision, the provision of law will tell you the procedure also in regulations. If there is any violation of regulations, then that judgment will be wrong. And where is that question when the code is a complete code? So where is the question of going to General Clauses Act, section 16? Lordship immediately said, yes, you're right. Notice the matter is once in a problem with the Supreme Court is it will take time, the judgment, but then the law, this is a substantial question of law. So in Supreme Court, when you go, you have to be always noting down. And if you see, you have to always read the books, what we read is normally a law student will pass the exam just by reading the guide. And they just go through and then finish it through the guide and then come. But okay, that is clear only. We don't know what to read, what not to read, and we want to pass the exam. That is the most important thing. But after passing that law, then when you are practicing, you have to be thorough. And first step is when you are going to High Court or a Supreme Court, what is the question of law and what is the question, a substantial question of law only will be discussed. Unless you are on that subject, the chances of your appeal being admitted itself will not be there. And that is why you must keep it in mind. Now, why I taken the Lordship's, this judgment is always, we go to, I used to, that there are people, if you see only one film in a year, you remember everything. But a person sees 100 films in 1 year, he can't remember. So whenever I as a teacher, I realized you take one standard landmark judgment and then analyze it. Then everybody will remember, will never forget it. That's what I learned as a teacher for almost 35 years. Secondly, why I taken this Honorable Judge Dr. Jayachandran. Jayachandran sir is a very highly qualified doctorate in law. But not only that, his knowledge is very good, very in-depth. And he is a strict votary of procedures and formalities. He listens to the matter. You ask anybody, I never appeared before him, Lordships, but everybody says he listens. He gives you time to and hears the matter. And fourthly, when the matter came, Lordship realized this is a matter of technical nature. So we'll try to put some life to this. As on date, all the important judgments Lordships have covered. And then the reason. So how are we going to talk about question of law, substantial question of law, and the matter of facts using this judgment? That is the reason why I've taken it. Another thing we understand from the Lordship's approach, that is, whenever a magistrate decides a particular case, suppose you file a private complaint and then process is issued by the magistrate, then Lordships gives 90% importance to the magistrate. He doesn't disturb them. Even in I was up in Supreme Court, I was appearing Abhay Oka and Justice Datta. They told that the kingpin of the entire criminal jurisprudence and administration is the magistrate. And the magistrate applies its judicial mind, procedures, and then decides issue summons. Then if the High Court using 482 will continuously interfere, stays, and then passes the order, and extraordinary circumstance only it should be passed. It was a case in 202, police inquiry when you are in a different state. They were checking whether the magistrate applied the mind or not, taken cognizance. Before that, you applied the mind, then you should not interfere. Otherwise, what happens is in a 3-layered system, layer 1 is the magistrate. You go to the magistrate, they spend time. And then within a short, they have timelines. Within such time, they have to finish it. Then you immediately, this is all rich people's domain now. And they will immediately appoint a very senior counsel who appears before the High Court. And High Court tuck and it gives stay. That's all, the case dies. And if you insist on hearing, you will be dismissed, quashed. Then in Supreme Court, in SLP, 100% it will be dismissed. So that means there is no justice for the persons. That is the present system. So we are now coming in a particular case. It was dismissed like that. And I am coming before the court on perjury as well as recall. I've done a detailed research on these items and we will discuss that. But coming to this particular aspect of the Lordship's thing, we are going further. And each and every paragraph of the judgment will be, that is basically citations relied upon. I would like to deal with it. It is more boring. It is not like, this is for the person's hands-on, student of law, you have to go through this. And young lawyers building up their career and then how to approach what is question of law. Now we will discuss little theory. I'm talking to the students as focused is the question of fact and the question of law. There are two things. And, question of law is, you will understand like this. The Constitution doctrine of separation of powers is one of the basic features of our constitution. So there are three state organs are there. Judiciary, and judiciary, the role is interpretation of law. That is the role of a judge. He interprets the law. And in his judgments, he settles the law. Now, the next executive is there and the legislature makes the law. That's clear. Now we are interested in these things. So, in other words, the question of law is the domain of the judge. He interprets the law through the process of interpretation. In this case, one possible interpretation was the judge has decided that appellant has committed an offense attracting section 193. But next stage he is gone. That is 193. So there is a 340 is there. You understand? 340 is the next judgment. You understand? In that section 340, there is a law, a clear law, which clearly says that this is not a case where you can just like that decide. And one has to decide on the basis of interest of justice, interest of administration of justice. That is, the law is there. Section 340 CRPC says the procedure is set, and also how it should be interpreted is clearly laid down in the law. And that he took up. Understand? So facts is basically from the litigant side. That is, A files a petition, complaint, and B will be countering it. So judges will listen both the sides based on the evidence available, and then they will decide. So this is a facts pleading, everything is from the litigant side. Whereas matter of law is before the judge, interpretation process. Then the next question of substantial question of law is involved. In a case like this, before the lordships I just explained in Justice Abhay. Here there is a law, section 34(4) of the code. But the NCLT, he overruled the restraint order of the Honorable Madras High Court. That technical member passed the order, completely overruling one. And the lordship did that technical member did not discuss the issue. So when you don't deliberate the issue raised and take some other issue, that's called as without jurisdiction. This Muhammad Noor, Anin Mix, and then Bilkis Banu's case, everywhere you can see they become per incurrum judgments. They are called as substantial question of law. That is, there is a question of law. Law is there, well written, precedents applicable there, but then the judge doesn't apply that, misinterprets it. Then that becomes a substantial question of law. Then only Supreme Court will entertain you. So I hope the students are clear on this matter. So what is question of fact, matter of law, and substantial question of law? Justice Abhay Oka, recent lecture, you please can read it. In that, he was delivering a lecture before these advocates on records exam. Then the lordships have said, many people asked that you are daily reading 40. Is it possible, humanly impossible to read? Will you really read all this and come? One lawyer asked, a student, lawyer. Then lordship said, you are right. I don't want to tell something else. Many a times we just come prepared or not prepared and sit. And we will ask the person, what is the substantial question of law you are raising? And same thing he asked in my case, the other side. Such a senior counsel is dumbstruck. And then we knew that is unprepared, matter is solved. So we are thinking that judges are dismissing and all. Their level of knowledge is pretty high. And if whenever you are preparing the petition, you please read this judgment of Dr. Jayachandran and then build up the case. Otherwise, it's waste of our time, just like the telling unprepared. It will cut a sorry figure. It doesn't need much of our time. understand what is the basis on which the petition was filed. Point one. What are the main things? Second, what was the counter, all that, and what is the basis on which the judge decided? Judgment is the law enunciated by the judge, the court. You understand? Order is don't bother, but a judgment is he lays down the law, settles the law, confirms the law if it is existent. Otherwise, through the process of interpretation, he'll make another law. But then within the framework of the legislature. Unless you are comfortable there, you cannot move further. This is very important, dear friends. Thank you.